Well, it's a very great honor to be here. Thank you all very much for coming. And thank you in particular to ISI and to Anne Paolucci for this award. It's really a very great honor. Well, I'm going to talk about law and judicial duty. And you'll see it's a puzzle. It really is a puzzle. But a puzzle that doesn't just involve little pieces of wood, that eventually requires a solution in some ideals, profound ideals. The puzzle concerns judicial review. Judicial review is said to be the power of judges to hold government acts unconstitutional, in particular, to hold statutes, legislative acts, unconstitutional. And it's said to be a great innovation in American law. There are a number of innovations Americans have had in government and politics, and perhaps the most distinctive of these is said to be this thing, judicial review. But it's puzzling, because the Constitution doesn't say anything about judicial review. It has a hint of something that might look like it, but only a small little hint. And on the whole, one has to read the Constitution 2 or 3 times, and you think, well, where is that judicial review if it's so important? Perhaps they forgot it. And indeed, that seems to be the case. They left it out. And so there's a bit of a puzzle. If this thing is so important, this judicial review, where is the authority for it? Where do the judges get their authority to hold statutes unconstitutional? And if it's not in the Constitution, why did the judges start doing this? So the conventional answer is a story of judicial self-empowerment, as if the judges, by their own bootstraps, pulled themselves up and gave themselves a power to hold statutes unconstitutional. Allegedly, they created it, or if they didn't create it out of whole cloth, they somehow patched it together, developed it, and then established it through precedent. Allegedly, they recognized that the Constitution should have included judicial review, but somehow left it out, and that therefore it was necessary for them to enforce constitutional law and to resolve cases by deciding constitutional questions. And if the Constitution didn't specify this, perhaps they had to do this through their own efforts, through their own power. And so the most significant power of judges has come to seem as if it arose from an act of original judicial activism, thus perhaps setting a model for judges ever since. So there are a number of different versions of this story, and they offer different chronologies. One version says that this act of creation occurred in 1803 in Marbury versus Madison, when John Marshall, Chief Justice John Marshall, gave this thing, judicial review, the force of a precedent in the Supreme Court. Another version, recognizing that this is a little improbable that a judge somehow pulled judicial review out of a hat, suggests that it happened in the 1790s, when federal judges slowly moved towards judicial review. Another version, recognizing this too is a little improbable, suggests, well, perhaps the framers intended it, but left it so understated that the judges had to develop it into something concrete. And so the judges, although they found it in the Constitution, nonetheless had a lot of work to do to construct and make practical this judicial review. And then another version, recognizing it has to have earlier foundations, says, well, perhaps state Supreme Court justices, Virginia, New York, wherever, reached decisions in the 1780s, already before the adoption of the Constitution, under state constitutions. And they slowly moved towards something called judicial review, and then the federal judges had something to work with when they more fully developed it. Now, each of these accounts, and there are yet others, I won't bore you with the full panoply of different versions, but they're all more or less the same. They have different chronologies, but they all assume that American judges established judicial review in their cases, thus giving it the support of precedent. Now, this is, of course, an account of judicial review that is very flattering for judges. It suggests that judges can fill in gaps in the constitutional structure, that although the Constitution did not establish judicial review, the judges could supply the defect. Such, at least, is the conventional theory. Well, I got into this by accident. And it's been a long journey. Sometimes one starts a journey, you think you're going to one place, and you end up somewhere else. And that, I'm afraid, is what happened to me. About 10 years ago, after finishing another book, I thought I should just do something, a small project. I would edit the manuscripts on judicial review and publish them. I thought there are only about 6 cases. I know the manuscripts fairly well. It wouldn't take more than 3 months. Well, that was 10 years ago. I realized there might be a few more than I'd thought. So I started driving down the East Coast from north to south, stopping at historical societies and state archives and county courthouses, and was delighted. I found other cases and decisions that I hadn't known about and that no one had heard about. That was very exciting. Until the 3rd or 4th iteration of this trip, it was getting rather fatiguing, eating a lot of bad food, staying in bad little motels. And every time I came across a new case, my stomach would turn because it became quite clear this project was much larger than I'd anticipated. In fact, would consume my life, which it eventually did. So the question is, what kept me going? Why did I continue? I almost abandoned it. And about halfway through, fortunately, I realized that there was a reason it was so interesting. It was because the evidence was so odd. There was something wrong about this evidence. It did not fit the theory. And for an academic, that's kind of fun. And so I realized I had to finish. Let me give you some examples of the sort of evidence I found that seemed fun at first, and then intellectually provocative and serious. 2 instances from North Carolina. The first concerns a woman called Mary Brown. Mary Brown turns up in Fayetteville with a friend, Thomas Cabine, somewhere around 1783 or 84. She apparently is very appealing because all of the apprentices and servants in Fayetteville begin to pay her visits. And to subsidize these visits, they steal from the folks they work for. All sorts of knickknacks disappear and turn up essentially on the black market, and they spend time with Mary Brown. Indeed, soon, many householders start paying visits. And at this point, the more self-righteous men of Fayetteville decide it's time for Mary Brown to leave town. So what do? Like any good vigilantes, they tar and feather her, as well as her pimp. I assume it's her pimp. He doesn't seem to be a gentleman, Thomas Cabine. And they tar and feather them and throw them out of town. But that's not the end of the story. Mary Brown was quite enterprising, and she manages to get a prosecution of all the men, the righteous men, who threw her out of town. They're appalled. They thought they had done the right thing. Of course, it's an act of sheer lawlessness, and her lawlessness doesn't justify theirs. But they're shocked. Suddenly, they find themselves defendants. They're found guilty, and they have to pay fines, which they can't afford. So they petition the legislature of North Carolina to save them from having to pay these ruinous fines for beating her up and tarring and feathering her. What did the courts do? The next year, in December 1785, the Superior Court of North Carolina meets in Wilmington, the other Wilmington, North Carolina, and they pass a resolution in which they declare that the legislature has no power to remit or suspend fines imposed by the judiciary. This is actually a profound constitutional question. If there's a judgment against an individual, does the legislature, or for that matter the executive, have a right to somehow reduce that fine or get rid of it? The judge's position was that the fine had to be paid, and at that point the legislature could give back the money to the defendants, but that to remit a fine, remitting the fine, the legislature really was interfering with a judicial act. Well, this was an important constitutional question, and it's in this little resolution from Wilmington, and in fact there is no written record of it. We just have oral accounts that were then given the year later during impeachment proceedings of the judges. Okay, let me give you another. They got off, well, I won't tell you about the judges' misbehavior, but they did not get impeached. They appealed to the patriotism of the legislature by unlawfully deciding against some Tories.